I want to bring in my think tank. Joining us tonight, folks, here in studio, we've got with us criminal defense attorneys Michael Bixson, criminal defense attorney Trinity Hundredmark, and former Commander Major Crimes Division Lieutenant Colonel Adam Lee. First of all, I know there's a lot else to talk about tonight, but let's focus first on the verdict. Verdict is as big as it gets. Verdict on Jane Doe number 2, guilty forcible rape. Your reaction?
Number 2, Jane Doe number 2 and number 4. From the beginning, I thought they had the strongest cases out of everybody, and 2 even more so than number 4. Number 4, as we all know, has an issue with the 2 different stories not matching up. Number 2 didn't have that issue. So not entirely shocked that they returned the verdict as they did. Obviously we got a lot of stuff to deal with here because they're not hung yet.
We're going to get to all of that. I want to focus right now, Trinity, on the guilty verdict for Jane Doe number 2. Your reaction?
That one is the one that is the least surprising to me. I think of all the counts and all the Jane Does, that was the one that was the clearest. She had the best story. She was the most consistent. She reported it the soonest to law enforcement. And generally, those are things that juries like to see when they're going to convict somebody of this type of crime. The second part of it, I'm a little unclear of. I mean, I think that's a little surprising. I think the defense did some good things there in getting that count number 5 that they seem to be hung on at this point. But Jane Doe number 2 was definitely the best Jane Doe for the state.
All right, Jane Doe number 2 was the woman who had some sort of a prior relationship, Lieutenant Colonel, with him beforehand, and she spoke in a very soft manner, and I guess this jury really believed her because they're hung up on so many other things, but they believe number 2.
This really came down to credibility, I believe. She was probably the most believable of the 3 that were there for the rape charge. So. At the end of the day, it was about them believing her. There was no other evidence. There was no DNA like you had with Jane Doe number 1. You didn't have the mysterious witness that you had like you had with Jane Doe number 4. And so I believe they really believed her at the end of the day, and she's the one that they decided to convict on.
Let's go to Vic Bajaj, who joins us out in San Diego. He's an incredible criminal defense attorney out in California. And I'm trying to focus the discussion because there's a lot of places we can go all at once, but I want to stay first with the headline, which is tonight this jury has found that Kellen Winslow II, former football star, man who earned $40 million during his career, his father, local legend there in San Diego, this guy, they say, is a rapist, Vic.
Well, that's correct, and I have to tell you, I'm very disappointed in a number of things that I'm sure we'll touch on later, but you're correct in those very powerful words. They've convicted him of being a rapist, but I will tell you that one thing that's concerning me is, again, the elephant in the room. We always worry in cases like this about compromised verdicts, and when you have horrible witnesses and you have one that's kind of holding a little bit of water, well, you'd hate to believe that the jury came back and said, we have to find him guilty of something, so we're going to find the most believable. And that's what we've heard with your prior guest there, the most believable victim. And that is, in fact, Jane Doe 2 in this case. The jury, for all intents and purposes, they've reached their verdict. Sleeping on it overnight is really just something that's unnecessary in my book. And I try cases in this jurisdiction and others routinely, trials. And I've never seen this type of an order of operations. Sleep on it a little more, even though you've told us now that you are hopelessly deadlocked. Hopelessly deadlocked. Actually a legal term. It sounds like something we talk about over a cup of coffee. But hopelessly deadlocked is powerful. That means no matter what you say, Judge, no matter how much you give us to sleep on it, we've already reached an inability to come to these conclusions. I think the judge should have taken that verdict.
He didn't,
then they should have
though.
dealt with whether the prosecution.
He didn't, Vic. And we're going to be back tomorrow on Verdict Watch. It continues here, folks. Hey, our 13th juror question, folks. If you were a juror, do you think you'd have a clear picture of what happened between Kellen Winslow II and the 5 Jane Does? Let us know. Go to our Facebook page. It's Court TV is our handle. Vote yes, no. Leave a comment. Your reaction to what the jury has said tonight as well. All right, folks, big breaking news tonight in the case against Kellen Winslow II. A verdict was reached. He was found guilty of raping Jane Doe number 2. He was found guilty of indecent exposure related to Jane Doe number 3. He was found guilty of lewd conduct regarding Jane Doe number 5. He was also found not guilty of lewd conduct in reference to Jane Doe number 5. But it's not over. They sent out a note saying we reached a verdict on 4 out of 12. The judge got that note, then took the verdict for those 4, then sent the jury back to deliberate some more. They sent out another note. That next note said that we remain deadlocked. We remain deadlocked on the remainder of the charges. So there's some legal argument, and then the judge brings the jury back in. This is at the end of the day to give them what's called an Allen charge, which is an instruction on how to continue deliberations. But those deliberations aren't going to continue tonight. It was for tomorrow. So we had a verdict today, and the jury will be back tomorrow because of this Allen charge. Let's take a listen.
Here's what I want to do. I'm going to read another jury instruction to you. There are a number of things the court can do when a jury declares that they are deadlocked. This includes giving additional instructions, clarifying previous instructions, permitting the attorneys to make additional closing arguments if there's an area of inquiry that the jury feels would be helpful, or any combination of those 3 remedies. So I want you to go home tonight. I want you to come back tomorrow at 9 o'clock. And I know this is not the news you want to hear, but look, I know all 12 of you have invested a lot of time and effort in this trial. There's no question you've given up a lot to be here, and I know that. You've taken time away from your families, you've taken time away from your jobs, and I know that you all take this very seriously, and I can tell based on the length of deliberations and how well you paid attention during the course of the trial. So I'm going to send you home tonight, but I want you to think about if there's anything possible the court can do in terms of focusing an area of law that might need clarification, or if further argument from counsel might be helpful, or if you need additional instruction or readback. Sometimes juries that have difficulty reaching a verdict are able to resume deliberations and successfully reach a verdict on 1 or more of the counts. So please consider the following suggestions. Do not hesitate to re-examine your own views. Fair and effective jury deliberations require a frank and forthright exchange of views. Each of you must decide the case for yourself and form your individual opinion after you have fully and completely considered all of the evidence with your fellow jurors. It is your duty as jurors to deliberate with the goal of reaching a verdict if you can do so without surrendering your individual judgment. Do not change your position just because it differs from that of other jurors, or just because you or others want to reach a verdict. Both the people and the defendant are entitled to the individual judgment of each juror. It is up to you to decide how to conduct your deliberations. You may want to consider new approaches in order to get a fresh perspective. That's why I want you to go home and sleep on it tonight and give it additional thought. Let me know whether I can do anything to help you further, such as give additional instructions or clarify instructions I have already given you. Please continue your deliberations tomorrow morning at 9 o'clock. If you wish to communicate with me further, please do so in writing using the forms that you have available to you in the jury room.
All right, I don't have any statistics available, but I have seen that charge work in the past in cases that I've covered, that they get this instruction to go back in there and give it another go, give it another try, and juries come back with a verdict. So it can work. Let me bring back in my think tank. And Trinity, do you think it's going to work here? Do you think this jury could potentially tomorrow come back, send a note saying, hey, we reached another verdict?
Well, I think the thing that they've got going for them in terms of reaching more of a verdict tomorrow is that, people towards the end of the day were probably looking to get home, right? And so it's easier to say, we're deadlocked, we're done, let us go home, let us be completely finished. But now that the judge is bringing them back, they're incentivized to keep trying. They know they're going to be there at least all day tomorrow. They're going to miss work. They're going to be out. They might as well give it another go. I think there's a chance we could have some more guilty verdicts or not guilty verdicts tomorrow.
Michael?
I don't know. It's tough to say. I think it could go either way. I think right now they really are deadlocked on those issues. If the decision had to be made tonight, that'd be it. It'd be a mistrial. I honestly think so. Tomorrow that might change given the amount of time they're going to have to really review everything. But for now, I think it definitely could have been mistrial.
Yeah. Have you ever seen, Lieutenant Colonel, in any cases where you've been a witness where the jury was deadlocked and they came back and then had the verdict?
Never. I truly believe, like Michael, I believe they have made their decision. I don't see anything really changing. I might be wrong, I've been wrong before. But I think that they have made their decision, and when they come in tomorrow, they're going to probably hear the same thing.
All right, let me go to Vic Bajaj out in San Diego. Vic, I want to put the actual note up on the screen because there's one word missing that you mentioned. They say we remain deadlocked on all remaining charges. They're not hopelessly deadlocked. They're just plain old deadlocked, Vic. They could reach a verdict tomorrow, right?
They can if everything goes wrong. I mean, let me tell you something. What the judge did this afternoon is give an Allen charge again. Okay, so the first time he asked juror number, was it 6? I'm not sure who the jury 4 person is.
Number
but
6.
Whoever the jury 4 person is, this young man who's in, number 6. He said, well, maybe it would help or maybe not. I'm not sure. That's an Allen charge. The way that translates is go back and deliberate. So that's Allen charge number 1. And now you give Allen charge number 2. Now, I understand the other side of it is, well, they're not deliberating together, therefore it's not a real deliberation on record. I think that's hogwash. That's not the way it is in reality. They're going to sleep on it. They're going to think about it. They're going to come back and say, hey, you know what? Maybe I didn't consider this while I was catching my Z's at night, and that's dangerous. The defense earned a mistrial. And it sounds to me, frankly, and I practice right here, so maybe I'm biting the hand that feeds me, but in reality it sounds like the judge is doing whatever he can to make sure these jurors ask for more. Can I have more argument? Can I see more evidence? Can I have more of the specifics on the law? I don't know if that's the right call here. The jury's made their decision. They're deadlocked. Hopelessly or not, they're deadlocked. Now, in regards to how this plays out statistically, as you referenced in your opening on this segment here, I will tell you, every time one of my juries has had an Allen charge, they came back hung. They never changed their decision. And when you talk to jurors don't like the Allen charge because you have to understand you have 12 people back there who have together said, we're going to go out there and we're going to tell the judge and the court that we can't reach a decision. And then you have the judge on the ivory tower saying, go back and think about it, kids. There's more to think about. I think that's a little offensive, and jurors take that in an offensive way, and I don't see it changing the hung jury that we should see on these remaining counts tomorrow morning.
All right, let's check in on our 13th juror question tonight, folks. If you were a juror, do you think you'd have a clear picture of what happened between Kellen Winslow II and the 5 Jane Does? Because apparently some of these jurors don't. Otherwise, we'd have verdicts, wouldn't we? Vote yes or no. Go to our Facebook page, our handle, Court TV. It's been a day and night of breaking news in San Diego, and I'm going to try to walk you through it here so we can get you to probably the strangest twist of all of this day. First, we got a note, juror note number 4, which told us as of 1:55 p.m. local time, which is 4:55 in the East, the jury has come to a decision on 4 out of the 12 counts. From that note, the jury was brought in, delivered their verdict on those 4 counts. Then on the remaining 8 counts, the jury continued deliberations. The 4 counts, 3 of them were guilty, including forcible rape of Jane Doe number 2. So Kellen Winslow now facing up to 9 years in prison for the convictions, the 3 convictions from today. 1 not guilty verdict there. 8 more counts, they go and deliberate, send out note number 5, which tells the judge and the court and the world that they remain deadlocked on the remaining charges, on all remaining charges, which are 8. So from there, the judge then instructed the jury on how to continue their deliberations, but do it tomorrow. So all of that is bizarre, crazy breaking news. And in the middle of all that, alternate juror number 3 was called back to the courthouse because of the verdict. So at verdict time, the alternates were called to return to the courthouse. But in the phone conversation with the clerk who called him, he tells the clerk that I had a conversation with juror number 12, which I think the court should know about. Well, the clerk didn't follow up to get any information on it, so this becomes a cliffhanger of what is this testimony going to be from alternate number 3 about this conversation, and could it make the lawyer and the lawyers argue for and the judge just throw out the whole thing? What's going on? And throughout deliberations, we've been talking about juror 12 because of all the jurors, he's the one who's been more of a loner than the others. So he's been sort of the subject of a lot of discussion and a lot of things that we've noticed about him in reacting in the courtroom, etc. So then alternate 3 came to court, took the stand, and then this happened.
My understanding is that when the clerk called you to tell you that the jury has declared that they may be deadlocked, you had made a comment to her regarding juror number 12 that questioned or caused you to question whether he should be a juror on this case. Is that correct?
Yes, sir.
All right. Can you please tell the court what exactly it was that he said to you and when it was said? Was it today?
No, it was just before the trial went to jury. We were outside the courthouse out in front, and we were conversing, and I gave him my business card and said, hey, if you ever need help buying a big screen TV, I'm the guy to call. And he said, oh, I just bought one like a week ago. And I said, oh, cool, what'd you buy? And he went, and he suddenly got very, very like, oh, I said, now wait a minute. My memory is so bad. Just like that, and I went, whoa, I don't know if I want this guy on a jury. I mean, it just jolted me to the core, just the way he said it. It wasn't like, oh, I'm having a senior moment. He had this real struggle in his face, and he went, my memory is so bad. And I was like, wow. And I'm just telling you this because you said anywhere along the line, anything that seems that it might affect the trial in a negative way, we should report it to you. Now, obviously, you're the authority on all of this, but I just thought the court should hear it. I didn't want to have this entire case be thrown off and have it be on my conscience that I didn't speak up and at least say what I knew.
Okay.
And that I'm saying this under oath.
Okay, and you, just to describe for the record, when you were describing his description of the big screen TV, he was very animated and grabbing his face and looking.
His face, it was like he was like trying to remember the creation story or something. I was just like, easy, man, just ask him what kind of TV you got. But it really, the way it rattled him, rattled me.
Okay, so it has caused you to have concern about his
Memory.
short term or long term or both?
You name it.
Okay.
My biggest thing was, can this guy even remember all his testimony? Because
Right.
I took 2 notebooks once, and I could see over his shoulder, he was chicken scrolling. I don't know what he was writing. So.
Okay. Did you have any other discussions with juror number 12 during the course of the trial or any other time that would cause you concern about his ability to fulfill his duties as a juror?
Well, as jurors, we conversed in the hall and all got pretty familiar with each other on a sort of a friendly basis. And he was as genial as anybody else, but the way he joined in conversation was a little odd because he does have a foreign accent. I can tell English is not his first language. And not per se, but in the back of my mind I kept thinking, well, I know all these other people, they're all really cool. This one guy is kind of, I don't know, I'm just trying to figure it out. And the other day when he made that remark, I just, in my heart of hearts, I went, man, I don't know if I should tell the judge now or not, because the trial was still in progress.
Okay.
I'm doing this out of an abundance of caution to do my civic duty and to all of the work that went into this trial.
Okay.
It's not lost on me how much money and time and effort has gone into this.
Okay.
So I just wanted to make sure that the court was aware that that incident happened to me. What you make of it, that's up to you. I don't know. This is highly unusual, and this is the last place I expected to be when I entered my jury summons.
Amazing, right? That was alternate number 3, talking about juror number 12, who we've been talking about throughout deliberations. At the end of the day, though, the judge said it had no impact on the case. Neither side was arguing that juror 12 should be removed or further inquiry or anything. It may be an issue somewhere down the road, but you know, what does it tell us? It tells us a little bit about juror number 12. It tells us a lot about alternate number 3. Does a great impression of juror number 12. Let me start with you. Lieutenant Colonel Adam Lee is with us. Are you concerned that perhaps we have a juror who can't remember things, who's making a huge decision here, whether it helps or hurts either side?
I think it probably hurts the prosecution a little bit, but at this stage, not really. I think when it comes to an appeal, maybe so. That may be something that may be brought up at a later date. But, you know, he was honestly very graphic in his description of the conversation. I think juror number 3, the alternate number 3, had more to think about concerning juror number 12 than what he mentioned. I think there was probably some other underlying things that happened throughout the course of the trial that caused him concern that he may not have discussed with the judge.
Yeah, Trinity, at the end of the day, I don't know what kind of television I have in my bedroom. I'm not sure what we have in the living room downstairs. I think I know those. But is this a concern? Would you be concerned? If you knew that ahead of time, would you have the judge excuse this juror because he doesn't know what kind of TV he has?
No, I mean, that's something, even if that direct question had been asked during voir dire and he said, I don't know, that's not something that would have been concerning to me. That doesn't seem to me to be a very important fact. It is to alternate juror number 3 because he sells TVs. So he knows what kind of TV he has. So obviously that's important to him. What I'd be concerned about, and it could go either way, right, is that alternate juror number 3 seems to really want to get 12 out. What does he know and what is his alternate purpose? Why is he so interested in that? But as a defense attorney sitting there, he could be your holder, right? He could be the person that's holding this back and keeping it
You don't
deadlocked.
want anything
and you
disturbed.
don't want anything to mess. You know you've got deadlock. We don't want to mess with anything that's there right now. So that's why they're not saying anything about it, I think.
Michael, should he remain on the jury? Juror number 12?
Honestly,
based on
I think
this?
so. I mean, look, it's good to have an involved
What kind of
jury.
TV do you have?
Honestly, I have no idea. For any of my TVs, I'd be the wrong. They'd throw me right off that jury.
Yeah.
Okay. And I think it's good to have an involved, jury, and for them to be concerned about whether or not they can actually partake in this and whether or not they're being fair and impartial and following the facts and law. But this is something minor. This, for him to be concerned about him not being able to remember what kind of TV it is, I just don't think it really matters. I think the judge understood that. I think it's why he kept him on and why it's not going to be an issue going forward.
Now, here's my guess. Our guest in San Diego, our friend Vic, is not going to be happy with what alternate number 3 said. Exactly why, though, I'm not sure. So why don't you tell us, Vic, why is this a huge problem?
I think Vinny, you may be telling me I'm just an unhappy guy. I don't think that that's true, but Lieutenant Colonel was right about this. There's an underlying concern, whether that concern is based upon how he speaks, how he acts, how intelligent alternate juror number 3 perceives number 12 to be. All of these are things that need to be, crumpled up and thrown right into the trash can. We are entitled to a jury of our peers. Some are Albert Einsteins of the world, and some aspire to be that. But we don't make those kind of judgments. I'd agree with your guest there in your studio live that there's something else that concerns alternate juror number 3. I can tell you my wife has English as a second language. She doesn't know what kind of big TV other than it was the best and the biggest one she could possibly pick out of a catalog. Well, that doesn't mean that she's inept and can't be on a jury. So there are just so many offensive things underlying, I think, alternate juror number 3's comments, and I think we should leave it at that. But you're right about that. I'm not happy about his comments.
Oh, absolutely. And the other thing, though, about juror number 12, and the reason why it stuck out to us here, is that our reporters, Julie Janae and Shanley Painter, have noticed a lot, but more reactions from him in the jury box than anyone else. He's like the easiest to read. And when they go to breaks, many times he's by himself, he's alone. And it might be for any number of reasons. But that's why juror 12 was already sort of on our radar. Do you think there's anything more to all of this? Is it possible that this is the holdout one way or the other?
Possibly. I mean, we know that the jurors are really tight together, that they have this, they talked about this almost like friendship that they have, and it's a very tight-knit community, whether or not maybe he's just the lone wolf maybe, and, whether or not the defense is counting on him to sort of keep that hung jury at this point, possibly.
Yeah, and I mean, they're watching him just as like you guys are, right? They're watching his actions, they're watching who he's hanging out with, and if they think they only need one, and if they think he's that one, they think he's the one that's kind of going rogue, that's all you want, they're not going to want to get rid of him.
Yeah. So looking at where we're still hung on Jane Doe's 1 and 4 here tonight. Number 1, Lieutenant Colonel, obviously we had the reaction. Everyone had the same reaction, that this is a problem. Her daughter comes in to testify to try to bolster her testimony. Some people found it bolstering. Other people found, that makes things even worse when we talk about Jane Doe number 1. Then we have 4, who was the most emotional of all. There was no testimony that was more compelling than hers during the course of the testimony, because the way she took us back to that night and the way she described it, Are you surprised that Jane Doe number 4, there has not been a verdict on hers? Because I guess the baggage is some inconsistency in some of the statements.
I'm not at all surprised. I mean, you have to look at the amount of time that has gone by since that incident or alleged incident. And I think they had a problem. Most people have a problem with, when there's a lot of time in between the time of the incident and when you reported the incident. I know that really means nothing. If you know anything about sexual assault investigations, sometimes people wait years to come out and reveal that they were sexually assaulted. So we can't blame the victim when you come to cases when there's a lot of years in between. But I think what happened there was that the jury probably struggled with the amount of time that had gone by. She admittedly was intoxicated or under the influence of something, alcohol or whatever at the time. So is it possible it wasn't Kellen Winslow, it was somebody else? You just don't know.
And the other part of this, as we sit here tonight, and again, folks, deliberations will continue tomorrow on the 8 counts that there's been no verdict on, which focus on Jane Doe's 1 and 4 primarily. Trinity, someone believes Jane Doe won beyond a reasonable doubt. At least one. Otherwise, it would be a not guilty already. So there's a juror or jurors that believe her beyond a reasonable doubt. On the other hand, there are folks who don't believe Jane Doe number 4 beyond a reasonable doubt. Is there any way for a compromise?
Yeah, and I think that's what Vic's saying he was concerned about when they go home and they think about it, and that you've got some of these other ones. Did they come to a compromise with regard to that one? Okay,
you can all give me 4, I'll give you 1.
Yeah, we all agree on 2, so let's just go with that, right? And we can agree on the other 2 little minor things. Let's stop there. But are they going to come and compromise on 1 and 4? I think that's the real danger that's sitting out there for the defense attorney. Are they going to come to some sort of compromise and say, okay, I'll give you this one instead of you giving me that one? And that's the real danger of them going home tonight, is that they come back and do that.
And Michael, one of the other things that's been tossed around here by the judge is that there's a potential for some more closing arguments.
Exactly.
Have you ever done that, closing arguments after the verdict?
Honestly, no. I mean, the whole case is extremely unusual, right? Even just sort of get this piecemeal verdict out and for them to still be hung on certain counts and you get some, and the whole way that this is proceeding is really unusual. It's very rare to see something like this. Whether they come back and if they need more jury instruction, if they need more argument, it's certainly possible they could.
Yeah. Would you need time to prepare, or do you think you can make that argument immediately if the judge wanted you to?
Tonight, those defense attorneys are going home and they're preparing to make more arguments, do whatever they need to do, to possibly even, sway the jurors, not just from maybe a hung verdict, but maybe to not guilty.
Vic, have you ever seen closing arguments after a verdict?
I have not. Of all the trials I've handled, I have not seen it. I still would be extremely surprised if Judge Bowman allowed that to happen tomorrow. But for a quick moment, Vinny, if I can please dovetail off of what one of your guests just indicated, which is Jane Doe number 1. We're talking about Jane Doe number 1 and whether she was believable, perhaps bolstered by her daughter's testimony, perhaps quite the opposite. But I would ask, hasn't the jury in essence already acquitted Kellen Winslow Jr. of Jane Doe number 1's account? Because we understand there's a multiple victim allegation that's attached to the count with the principal victim being Jane Doe number 2. Now that multiple victim allegation has been found to be not true. Now we know that allegations used to be easy to find under a preponderance of the evidence. However, because it increases punishments in most cases, as it would here, to a potential life top, a big case, Apprendi versus New Jersey, United States Supreme Court. Every lawyer knows about this if they're arguing criminal cases. And this one says that if it's something that can increase the punishment, you have to prove it beyond a reasonable doubt. So I query, rhetorically perhaps, has the jury already acquitted Kellen Winslow Jr. of the crimes alleged by Jane Doe 1 by not finding the truth to the allegation that the prosecutor wanted, that being the multiple victims allegation?
Absolutely. That's a great point,
changes,
Vic. Huge. That's huge tonight, and could be an indication on the way they're thinking, or could be a real issue if there's a verdict of guilty down the road. All right, we've got more to talk about. I want to hear from you now, though. 13th juror question. If you were a juror do you think you'd have a clear picture of what happened between Kellen Winslow II and the 5 Jane Does? Let me know, yes or no. Those results coming up.
Superior Court of the State of California, in and for the County of San Diego. The people of the State of California versus Kellen Boswell Winslow II, also known as Winslow Kellen Boswell II. Case SCN 387417. Verdict, count 4. We, the jury, in the above entitled cause, find the defendant, Kellen Boswell Winslow II, guilty of the crime of rape by force or fear in violation of Penal Code Section 261, parenthesis A, parenthesis 2, as charged in count 4 of the information regarding Jane Doe number 2.
And folks, that's the headline from tonight. Kellen Winslow II, now a convicted rapist. That's what the jury said. Jane Doe number 2's allegations were found to be believable beyond any and all reasonable doubt. So he's a convicted rapist. He's facing up to 8 years in prison for that charge. But there were 8 charges where they did not yet reach a verdict. So our 13th juror question for you is a result of everything that's gone on today. If you were a juror, do you think you'd have a clear picture of what happened between Kellen Winslow II and the 5 Jane Does? And 66% of you say yes. So 2/3 of you could reach a verdict, but 1/3 of you couldn't. So you know what happens if you're all in the same jury? You're hung, folks. Your 13th juror is hung and deadlocked tonight, just like our jury is on 8 of those counts. All right, let's check back in with Chanley Painter, our Court TV legal correspondent, with a look ahead to tomorrow. Chanley.
It was an afternoon full of twists and turns here in the case of California versus Winslow II. After a conviction for counts 4, 6, and 9, the judge inquired of an alternate juror, and then another note, Vinny, saying that this jury remains deadlocked on the 8 counts they haven't reached a decision on. So the judge gave the Allen charge, saying that if they need additional help, that they can have that additional help, but they were going to go home for the evening, sleep on it, and return tomorrow morning, 9 a.m. Pacific time, to resume deliberations. And that's what we can expect tomorrow. Will they have another note or another question? That is to be seen. Or will they be able to even reach a verdict on those remaining 8 counts that could potentially expose Winslow II up to life in prison? We do know that some of the options the judge could employ tomorrow are under Rule 2.1036 to assist the jury if they are deadlocked tomorrow. That could be additional instructions. It could be clarifying instructions. It could even give the attorneys the option to do closing arguments again, or any combination of the measures. We will see tomorrow morning if this night of sleep and rest helps them at all to reach a decision. Vinny, back to you.
All right, thanks so much, Chandler. Let's check back in with our think tank, and we're short on time here, so let me start with Vic. Only have about 15, 20 seconds per person, so what do you expect to happen tomorrow in 15 seconds?
Excuse me.
I think the jury is going to come back well rested, having their cocoa at night, talking with their significant others about how their life is going to get back to normal. They're going to remain hung on the remaining counts, and this hot potato is going to end up quickly back in the district attorney's lap.